Hey everybody, welcome back to SEC Roundup. I am Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the co-host for today's SEC Roundup. Joining us today for our annual SEC Enforcement Division report, we have a number of distinguished guests. So we'll start with Rodrigo Seira from Cooley. Rodrigo, thank you for joining.
Thanks for having me, Nick.
Lisa Troe, Independent Public Company Director. Lisa, thank you for joining.
Glad to be here. Thank you.
Sarah Concannon from Quinn Emanuel. Sarah, thank you.
Thank you, Nick. Good to be here.
Art Zwickel from Paul Hastings. Hi, Art.
Hello, and happy to participate.
And of course, Tom Zaccaro. Tom, will hit you up last to get the latest and greatest on MNPI insider trading. So each of you, I am very grateful to say, is an advisory board member of ICANN, but you also are respective subject matter experts in a number of the topics that were and are regularly covered in the SEC's Enforcement Division annual report. So we've done an SEC roundup like this each year. Every year, the Enforcement Division puts out a report detailing what has happened in the Enforcement Division's prior fiscal year. And there are numbers about, the total number of cases brought, the total amount of monetary sanctions collected. And then there is some breakdown in sort of industry by industry or subject matter by subject matter. And so we've gathered you all to talk about a number of the subject matters that are addressed in the report. I will just start out by saying some of the macro numbers, and I know, Sarah, you've taken a deeper dive in some of these numbers, so feel free to comment, but $8.2 billion in monetary sanctions collected with an asterisk. Like a lot of these numbers come with an asterisk. Over half of that came from a single case. And some of the other large numbers that added up to the 8.2 million came from particular cases. The total number of cases brought was down by 25% from the prior year. And the amount of money returned to investors was down 60% from the amount returned to investors in 2023. I don't think any of those numbers were the ones that were highlighted in the report, but it's sort of meaningful here. Particularly, I will note we are recording this as there's going to be a change in administrations for 2025. We're on the sort of cusp of the next administration naming the new chair to the SEC. So everything that happened in 2024 may be different in 2025, but that's for you all to comment on. Rodrigo, let me start with you. Obviously, you have been in the blockchain and crypto space for many years, follow this stuff regularly. I am a big follower of yours on X, so keep that stream of information coming. It'll keep us all smarter. What did you notice in the Enforcement Division's efforts in the past year? Like, what are the big things that happened in SEC enforcement and crypto or blockchain in 2024?
Sure. Thank you, Nick. And here's hoping that my firm never finds my X account. Otherwise, I think I'm going to get in trouble. I think if you're talking about the SEC's regulation of the crypto space, it's helpful to first set the stage with two kind of broad comments. The first is there's been a long-standing industry critique that the main or only tool that the SEC has used to regulate the space is through enforcement, right? And implied there is that there's been a lack of rulemaking or really engagement with the industry to figure out how to make a regulatory framework that is purpose-fit. This has been a criticism that's not only been leveled by the kind of ardent cypherpunk part of crypto, but also by sitting SEC commissioners. And then I think the other macro comment to make is I think we've seen a concerted shift in the SEC's enforcement priorities as they've moved away from kind of an initial focus on token issuers around the earlier stage of the ICO boom, and under Gensler particularly moved towards focusing on more intermediaries. And I think what we see in this last year is basically the last chapter of this second wave of enforcement that is focused on intermediaries. It's I think helpful to maybe break down the enforcement actions by the statutes that they're enforcing, the types of claims that they're bringing. I think one of the notable focuses of the SEC has been bringing enforcement cases alleging failure to register as a broker or dealer, which has been a claim that they've brought with more increasing frequency. To my knowledge, the last crypto case that they brought was against Cumberland, which is a Chicago-based market maker, and that was charged with basically operating as an unregistered dealer. It's really this is notable because I think it somewhat evidences the limits with the current regime. Because Cumberland is an established financial player, they actually have a registered broker dealer, but they weren't able to get that approved to trade the crypto assets that they wanted. So they're basically trading the crypto assets outside of that entity. And if you look at the response from Don Wilson, the founder of DRW, it's notable in how kind of combative his stance is. And he basically says, like the SEC's current policy of coming and register is a facade, and the system doesn't work, and we look forward to basically having our day in court. So I think that's a notable case to highlight. There's two others that are alleged broker registration violations that I think are notable. The first is Mango Markets. This was a platform that allowed users to margin trade, so somewhat of an crypto exchange, decentralized exchange, and they were charged for failure to register as a broker. That order, I think, was striking to me when I read it, just seeing the level of technical understanding that the staff has developed about crypto products. They are talking about the order flow of a user, like through the interfaces, how it's through the smart contracts that are deployed on the blockchain. So it's, I think, evidencing that the staff has really learned a lot and gotten up to speed and has some technical chops here. And the other case I want to mention is Rari. This was a lending protocol that was also charged with operating an unregistered broker. And I think one of the other notable things here is they settled with the Rari DAO, and they also settled with the foundation. A lot of the crypto projects that have launched tokens in the last couple of years have used this structure that leverages some sort of offshore foundation, most typically in Cayman. And the independence of these entities hasn't really been tested in the courts, but we're seeing the SEC in actions like this basically pressure test whether these are really separate entities or whether they're just going to be one other defendant that they tag on, right? Moving away from the 34 Act, there's one I think notable case that they brought against Barnbridge DAO alleging violation of the Investment Company Act. And here they actually alleged that the yield pools were not unregistered brokers like they did in the Rari case, but actually unregistered investment company, which to my knowledge is the first time that they've made that allegation. They also charged Galois Capital, which is a Florida-based investment manager, with failure to with Advisor Act violations, mostly related to their failure to custody assets with qualified custodians. This has been a pain point for the crypto industry for the last couple of years, especially as more and more funds become registered investment advisors in order to be able to pursue liquid strategies. The SEC has, at the same time, made it much harder for qualified custodians to crypto custody, while kind of saber rattling about investment advisors not keeping all of their crypto assets with QCs. So I think this enforcement action, got a lot of people's ears perked up. Now, the facts of this case were, I think, extreme in some extent. Like the Galois Capital, I think, had something like 50% of their assets on the FTX platform when it went bankrupt. So maybe it was like a particularly egregious violation of the custody requirements, but nonetheless one that I think worried a lot of people. And then I think they've still brought some enforcement actions for unregistered offering of securities under the 33 Act, but they've shifted a little bit, and I think try to break new ground in a way. I think particularly notable was the Flyfish settlement. This was a settlement against a social club that was developing a sushi restaurant that sold NFTs as memberships. Now, these NFTs were sold to fund the development of the restaurant and were also tradable, and you could rent them. So they had some financial aspects that I think made them higher risk than just your garden variety NFT. But I think, as you see here, the SEC trying to kind of stake ground in the NFT world. And then the final case I thought I'd chat about was Abra Earn. And this, I think, represents kind of the final step in the SEC regulating the different types of crypto yield products. You've seen them move from targeting the centralized lenders, things like Celsius, BlockFi, and then move towards the yield programs that the exchanges have. And I think Abra fits in this context. I think and I'll end with this. I think one of the most notable things to talk about in terms of the SEC's enforcement actions this year is not only the actions that they have brought, but the ones that they have welsed but not yet brought, and everybody is kind of holding their breath to see what happens in the next couple of weeks, right? And the two most relevant ones there, I think, are Uniswap, which is the most popular decentralized exchange, which announced that it had received a Wells notice, which I don't know that it was disclosed specifically, but we can assume it relates to operating an unregistered exchange or broker dealer, and potentially also registration violations for the distribution of the UNI token. And then the other case that was Wells but hasn't been filed is a potential action against OpenSea, an NFT exchange. So it'll be interesting to see what happens in the next couple of weeks with those cases, and if the current administration makes a move there.
Wow, that's a very broad-based enforcement list. I mean, 33 Act, 34 Act, both 40 acts, and all different kinds of players in the market. And you just hinted at this, Rodrigo, but obviously, well, not obviously, but two of the sitting commissioner, Chairman Gensler and the other Democratic commissioner, have indicated they will step down by inauguration day. I mean, we probably could go on for an hour about this, but how do you think the landscape you just painted, it will be different in 2025, if at all, speaking in broad strokes?
Sure. So it's been quite an experience being a crypto lawyer these last couple of weeks, because I've been getting calls from a bunch of clients that are acting like it's the day after prohibition ended in the United States, right? And I'm cautiously optimistic that the change in administration signals a much more favorable regulatory regime for crypto. However, I think we need to be more nuanced about what specific actions are more or less likely. So I think what I think will be evident most immediately is a sharp decrease in new lawsuits that the SEC brings for strictly registration violations, right? I think if you read Commissioner Hester Peirce and Commissioner Mark Ueda's statements on this, it's clear that they don't think that the current framework works great for crypto, and they don't think that bringing these registration enforcement cases is the best use of time, right? So I would expect that those decrease significantly. I would distinguish from those any type of claim that also includes allegations of consumer fraud or any other consumer harm, which I think any SEC is still going to be very interested in bringing. And I also would distinguish the cases that the class action lawyers and the private bar can bring, right? Notwithstanding that we might have a much more favorable SEC chair, the law is not going to change on January 20th, right? And we now have some case law, particularly in the Ninth Circuit, that is very favorable to some to class action plaintiffs, and I could see them continuing to bring on a lot of these claims against investors and against DAOs. So I don't think that's going to change immediately.
Yeah.
In terms of other things that the SEC could do, I think they'll probably get rid of some of the more unpopular proposed and adopted rules, things like SAD 121. I think it's potentially shelved. I think their proposed amendment to 3B16, which expanded the definition of exchange, potentially gets shelved. And I think you'll also see kind of a concerted effort on the part of the administration to re-engage with industry. I don't have that many gray hairs, but I've been practicing long enough to remember where you would take crypto clients to meet with the SEC and you would tell them what you were going to do, and it was all kind of done in good faith. Over the last administration, that's totally broken down, and I think that's not lost on folks like Hester Pierce. So I think she's going to be very interested in restarting that dialogue and potentially, giving no action relief in that context. And then, I think the ultimate goal is new legislation. The chances of that happening, depend on Congress being able to do something. So I wouldn't bet too much on it. But it does seem like there's broad alignment around at least pushing something around stable coins forward. I also think that that's a piece of legislature that could be particularly that could appeal to Trump, because I think you could frame it in the context of extending the US dollar hegemony. So I'm hoping that the White House will get behind that. And then I think that's the Trojan horse, and we ultimately end up getting market structure regulation farther down the line. So I think cautiously optimistic, but maybe a little worried that people are overcorrecting is my take on this.
Yeah, well, I guess time will tell. You mentioned a lot of topics in there. One of them was the status of rules that could affect the industry. And of course, the Northern District of Texas recently issued a ruling in a crypto case that had a parallel private fund advisor case challenging the SEC's definition of dealer. That definition by rule was struck down, and so maybe that takes the win. Unlikely to be appealed from the Northern District of Texas to the Fifth Circuit, certainly not in a changed SEC. But as you say, maybe that takes some wind out of the sails for other rulemaking activity that was pending. So we'll see. Without too much whiplash, I want to change from the crypto industry, and I guess I could use SAB 121, was it, as a shift. But Lisa, Troe, let's shift from crypto to accounting. Obviously, you were a senior member of the enforcement staff as an accountant at the SEC. You follow the changes both at the SEC and PCAOB. What did you see in the enforcement division's annual report, or what you're aware of generally, that were significant accounting issues and developments from 2024 as we look into 2025?
Yes, I will move to the, as Rodrigo called it, the garden variety type of enforcement actions. And indeed, for this last fiscal year, as I looked at those statistics, 40% were broker-dealer, investment advisor, investment company related. 17% securities offering, delinquent filings 10%. That's low-hanging fruit, and then 10% relating to accounting, financial reporting, disclosure, auditing. And as was the case last year, gatekeepers front and center. And I would say that both gatekeepers and the enforcement division's statements and seemingly incorporated into its cases effort to foster a culture of compliance are really the two areas for my area, right? There are the evergreen investor risk areas of overstated revenue and that sort of thing, but two big gatekeeper cases and one case which I think is a bit unusual on the compliance side. So continuing from last year's Roundup, Prager Matus, last year, the commission brought an action concerning independence failures. The audit firm had dozens of engagement letters that included indemnification terms. And so an action was brought last year that was settled this year in conjunction with the settlement of a case brought this year against the same firm for audit failures. And Prager Menace was the auditor for FTX. Of course, the FTX was a crypto asset trading platform. And the audit failures were significant. The commission brought a complaint both last year and another one this year. This year focused on the audit failures. And the firm itself, FTX's auditor, the engagement partner had just met Sam Bankman-Fried. And right after that, the firm accepted FTX as a new client, although there were red flags that the firm had in even accepting FTX as a client. But nevertheless, they accepted him as a client. Audit reports were issued. Let's see, July 2021, April 2022, and November 2022. Of course, FTX filed Chapter 11. So the alleged audit failures included that the auditor did not understand the company's business, did not understand FTX or the crypto asset markets. The auditors knew about the interconnectedness between FTX and Alameda Research, which was the trading firm that was owned by Bankman-Fried. That the auditors knew that FTX planned to go public and that it was raising private funds, through equity investors. But nevertheless, even though the firm had red flags about both the client and itself, went ahead and did the audits. So Prager agreed to a settled permanent injunction, penalties of $1.2 million. It seems like that the staff, and it's really the third area that I think is affecting, or they try to affect for all types of cases, is if you cooperate, we'll give you a reduction in penalties or no penalties. And the staff seems to think that for this one, that was the case. So, okay.
Yeah, penalty for a cooperation.
Right. Penalty for cooperation. So, permanent injunction. And that second complaint in 2024 included, of course, aiding and abetting, as well as the audit failures. The other gatekeeper case in this last fiscal year that I'd like to talk about is Benjamin Borgers. I may not be pronouncing the name right, Borgers, and his firm BF Borgers. So from January 2021 through June 2023, there were 1,500 filings, 500 of which included audit reports or reviews by the auditors, 75% of which were not performed consistent with the PCAOB standards. Specifically, I should say what they settled to. So this really was a sham audit mill. And as I think it was the press release by the staff said that it was one of the largest wholesale failures by gatekeepers in our financial markets, which certainly is the case. So the firm agreed to pay $12 million in a civil penalty and the individual $2 million. Sidebar, I guess he made a lot of money doing these audits. And then, of course, permanent suspensions from appearing or practicing before the commission as accountants. So interestingly, too, this administrative proceeding was settled May 3rd, 2024. And because it was so pervasive, affecting 369 clients, the CorpFin and Office of Chief Accountant staff issued a statement on issuer disclosure and reporting obligations in light of Rule 102E, order against BF Borgers CPA PC, because of course, all of those audit reports cannot be relied upon. So if there are any filings that are going to be made after the order, financial statements included therein need to be audited by PCAOB registered auditors, of which BF Borgers is no longer. So to the extent there are multiple financial statement periods in the, like a 10K, which of course there are, all of those prior years need to be re-audited, and then query previous filings, filings made prior to the entry of the order. So will those need to be amended? Because there's an audit report included in a previously filed 10K, which cannot be relied upon. So the staff has issued a statement saying, we're working through this. Pay attention. You need to do this. This is how you file your Form 8K change in accountants.
Wow.
So that's interesting. The allegations, of course, 102E improper professional conduct, and also violating and causing violations of anti-fraud, record keeping, other provisions like SX, like the issuer needing to have an auditor registered with the PCAOB. So some of the conduct allegations include they did not have planning meetings, which are required. And at a planning meeting, the audit team discusses the client's business. So there's an understanding of the client's business and what are the risk areas. So those didn't take place, but the work papers reflected that they did. The staff would just take last year's work papers, change the dates, and that would be it. Not only did the engagement partner and the concurring partner, engagement quality partner, not review any of the work papers as required, but gave the staff the usernames to go into the electronic work papers and document that everything had been reviewed by everyone who needed to review it, even though that did not occur. So, audit sham mill and sham audit mill. So they were censured, permanent suspensions, of course, and cease and desist from committing or causing violations, and then the penalty of 12 plus 2 million. So that's a big gatekeeper case.
Yeah.
And we'll certainly continue to see gatekeeper cases as we have for years in the past, and surely will in the future. The third and final case I'd like to talk a little bit about, and I hope I don't step on Sarah's toes here, because this relates to R.R. Donnelly and Sons, and it's about a cyber breach that occurred. The allegations, or the administrative proceeding, alleges and then orders a cease and desist for disclosure controls and procedures and internal accounting controls. Donnelly paid a $2.125 million civil penalty. I'm particularly interested in this case, frankly, because as a public company director, audit committee chair, public company privacy and cybersecurity committee member, certified in cybersecurity oversight, National Association of Corporate Directors, certified in cybersecurity oversight, et cetera, et cetera. I'm particularly interested in this, and what I had hoped is, okay, well, looking at this case, what can I take back as a director, right? To management teams, to my fellow board members, what is it that we should make sure we're doing? But when I looked at the background in which this case was brought, it's kind of hard to get there. Donnelly was up for sale in May and August of 2021. A firm was increasing its holdings. The company received an offer. and that the chronology actually is kind of interesting that way. And even after the company issued its Form 10K, reporting its item 801, we've had a breach. We don't know whether it's material. We're working on it. We're investigating. There was an offer like 2 days after that by another entity offering to buy the company. And Donnelly was sold. It was acquired. So you have the company for sale, the cyber breach, 3 different 8Ks about the cyber breach. I don't see any investor harm here. The investors knew. And if a selling shareholder thinks that he or it did not get what it should have, it seems to me that that's a private action. It's a post-acquisition dispute matter, civil action, private matter, in my view. So there's sort of that background. And Donnelly, of course, is the former Yellow Pages company. It had been around a long time, and was viewed as a provider of marketing, packaging, print, and supply chain solutions. And they just never quite got into the, contemporary, modern. They never quite made the transition. So to me, looking at this as a director, what I see as allegations is that the company failed to execute timely a response to a ransomware attack. So they had in place controls that detected that there were intrusions occurring. The company engaged a third-party expert to help with this and other such information security matters. And the intrusions occurred from November 29, 2021 through December 23, 2021, December 23rd, 2021. And it seems that the company really just did not have procedures in place that the staff thought were quite enough. That's sort of my take on it. And there's some detail around that, but in the end, that's the way it looks to me. And so they had the procedures in place to detect finally after, November 29th to December 23rd is not a very long period of time. When you consider that cybersecurity experts say that the average detection period is 287 days, right? That's kind of, some are detected within hours or days, but the average is 287 days before something's even detected. So the internal control and disclosure control and procedures allegation really goes around that the information security folks did not ramp up to management decision makers quickly enough. So the first disclosure that I saw was December 27th by the company saying we've had a breach. Sarah, I apologize. This is just from my perspective as a director, hoping to take something away from it. So the only thing I can speculate, right, is that the case was brought because it's about compliance, even though there were no investments, investors harmed. But in the end, it just looks to me like the staff doesn't like the way they were doing business. It doesn't like something about their business operations. And investors apparently didn't care because they had full knowledge.
Yeah.
So, I found that one interesting.
Yeah. Well, it is interesting, and particularly interesting you're bringing it up because it's a financial reporting, internal controls. That's how it's couched. And
Right.
I know you're
That's
right.
how it's couched.
Sarah's going to talk in a minute more broadly about the SEC's policy towards cyber breaches and disclosures, but this one
Right.
is a weird one. for all the reasons
Right.
you said. Going back for a minute to the gatekeeper cases and the accounting and financial reporting cases more narrowly,
Yep.
setting aside
Mhm.
what do you think are the changes we're going to see in a new SEC? As the two cases, the two gatekeeper cases you cited are bread and butter. They're kind of shocking on their facts, but they're not shocking in the context of the kinds of cases the SEC routinely brings. Is
Right.
this area of accounting and financial reporting likely to change much in a new administration?
I would, my expectation is that because there are other areas that are of much more interest, that this program area will kind of stay at, maybe it'll stay at about 10% of total cases, and it's going to stay at sort of a level like this, and the staff will continue to bring the bread and butters, overstated revenue and that sort of thing. I would like to think that the cases that do end up getting brought are a bit more egregious than some of what we've seen, including this year, right? In terms of those garden variety cases. So I don't expect much change other than hopefully a little bit more scrutiny by the commission on what the staff actually wants to bring in terms of actions, even settled.
Yeah, I want to follow up on that and ask a very quick question, Lisa, and that is how those cases will be brought. At the end of the fiscal year, as you know, the commission dismissed 8 contested administrative proceedings involving 102E sanctions against accountants. Do you think that we're going to see a change in how the commission brings those cases, or is those are just anomalies that don't reflect a change in the commission's thinking?
Well, sidebar. I didn't see those 8, by the way, in this report, even though I believe those occurred prior to September 30th of 2024.
The dismissals did. Yeah.
I looked for them.
Yeah. Didn't get
I
mentioned.
think they occur in the numbers. I don't think anybody netted out the dismissals when they came up with the 583.
That's undoubtedly correct. Yes. I would like to think because the basis of and what the incoming administration is hanging its hat on is the same Supreme Court decision that caused the SEC to dismiss those 8 cases. I would like to think that will make its way into the SEC as one of those many federal agencies, but I don't know. I don't know about that.
Yeah, we'll wait to see 102E cases being brought in federal court, and then we can all have the answer to that question. Well, thank you, Lisa. That was very insightful. Since you broached the topic of cyber breaches and disclosures around cyber breaches, let's go to Sarah. Sarah, obviously your practice is very broad. Former senior official in the enforcement division at the SEC, your practice encompasses all kinds of aspects of cases in the annual report. But can you give us a sense of, in addition to the Donnelly case Lisa talked about, some of the other noteworthy developments in the SEC cyber breach and disclosure enforcement matters?
Sure, and Lisa actually stole none of my thunder because I was not planning on commenting on our Donnelly. And you hit on a theme that I was planning on commenting on, which is this concept of Monday morning quarterbacking, and also just the lack of guidance for people sitting at public companies or those of us trying to advise public companies on what exactly you are supposed to do in the cyber realm to fully comply with the SEC's expectations, which are somewhere on the level of perfection as opposed to material truth and accuracy. So the case that really highlights that, which is truly a fiscal year 2024 case, because it was brought in fiscal year 2024, and then we got a motion to dismiss decision in July, And then there just yesterday was another cyber breach case that kind of hits on some of the same themes. So that, of course, is SolarWinds. Everybody is familiar with SolarWinds because it was such a headline-making ransomware attack at the time at which it occurred that impacted many governmental, public sector companies, private sector companies, and really hit across the board. So the SEC brought a litigated action against SolarWinds and its former Chief Information Security Officer in late October 2023. And that was stemming from this ransomware attack, which was widely attributed to the Russian SVR, which is Russia's Foreign Intelligence Service. That case was unique at the time the SEC brought it, both for being one of the first cyber breach cases, but also for bringing claims against the Chief Information Security Officer, including disclosure claims against the Chief Information Security Officer. And the SEC used one of the tools in its arsenal, which is the Internal Accounting Controls statute. And so at the time it was brought, there was some significant criticism of the SEC for essentially trying to shove a round peg into a square hole by suggesting that inadequate, even if you assume that they were, policies, practices, and procedures with regard to cyber breach protections somehow fall within the ambit of the internal accounting controls. And what happened with regard to the motion to dismiss that came out with a decision in July is that the district court really sided with the naysayers and determined that, in large swaths, the SEC's case simply could not withstand the motion to dismiss standard of review because the SEC could not plead adequately that controls that with regard to cyber breach have anything to do with the internal accounting controls because it is simply too far removed from the financial disclosures that internal accounting controls are intended to actually regulate. And then the district court did permit one small segment of the SEC's case to withstand scrutiny, which was essentially that there had been granular statements in a 2017 security statement by SolarWinds with regard to things like password controls, protections built into its systems that the court found was sufficiently pleaded, again, has not yet been tested under a summary judgment standard or much less a trial standard, but sufficiently pleaded to state a claim for potentially material disclosure violation. But everything else, kind of disclosures around the breach, the things that were brought as internal accounting controls, the court simply said did not stand up. So the motion to dismiss also made clear, motion to dismiss decision also made clear that one-off disclosure failures are not sufficient to call into question the entirety of a control system. So merely because the SEC is able to state a claim for a potential disclosure violation stemming from the cyber breach does not mean that the company's entire protocols and procedures with regard to how it protects against those are called into question. Now, the other major critique of SolarWinds at the time it landed, in cases of its type, is that these are always cases that fall in the wake of a breach, an attack, ransomware. Some bad actor has come into your systems, and now you're in the SEC's crosshairs for, did I react fast enough? Did I disclose fast enough? Were my disclosures sufficiently accurate? Did I tell everybody everything they needed to know? All during a period of time, as Lisa points out, where you really don't know. Like, there's been a breach. You don't know who the bad actor is. You don't know which systems have actually been attacked. You don't know how far that information has gone. And now you've got the SEC looking over your shoulder saying, disclose more, disclose faster. And really, as I say, doing the Monday morning quarterback on, were you reaching that level of perfection in what you told people during this period of uncertainty? So what happened more recently in October is that the SEC brought actions against 4 customers of SolarWinds. These were all settled actions, which, many will say that settled actions can lead to bad law, because it's, some of the provisions and the tools in the SEC's arsenal are not being put to the test the same way they are in litigation. So these 4 actions really fall into 2 buckets, and those are 2 SolarWinds customers who disclosed, but in the SEC's estimation did not sufficiently disclose, and 2 that did not disclose, and therefore in the SEC's estimation had a material omission. And both sets of cases come to really call into question kind of the SEC's approach to materiality, and the question of what is material to a reasonable investor as part of the total mix of information, which is the actual standard for disclosure, versus a nice to know standard, or a perfection standard, which is not the law and never has been the law. But because these are settled cases, it really fell upon Commissioners Peirce and Ueda in their dissenting statement to point out kind of some of the difficulties of having the SEC take this position in a settled case, and what sort of guidance that provides to public companies and their boards, who are then trying to determine what do we need to do in the wake of a cyber breach. So, for example, the SEC took fault with the failure to disclose that the threat actor was in fact a state actor during a period of time, again, where that was not known to a level of certainty, 110%. It was suspected, it was rumored, et cetera, et cetera, et cetera. But the SEC actually found that it violated disclosure obligations for them not to have said, in fact, this is a state actor. And reasonable minds can also differ on whether a reasonable investor actually cares, and that somehow it might matter to me as a customer. It probably matters less to me as an investor. But the SEC, again, kind of weighing in after the fact on that. So that brings us to yesterday's case, which is ICBC, which is another blame the victim case, but also interesting in its own right, because ICBC is a broker-dealer. And so this was a case that was resolved with no penalty due to self-reporting, cooperations, and remediation. And really what it fell to is that because of the ransomware attack, ICBC was put in a situation where, one, it had to sever connections to some of its clearing brokers and other entities with whom it did business. This is not stated in the SEC's order, but the presumption is that they thought that that might be a deficiency in their protocols that allowed access to their systems. So they cut those off. They also went to manual reporting with regard to a number of their obligations. And so this was a books and records violation, that they couldn't keep up with their their reporting obligations, doing it manually in the wake of this breach, and therefore they were not able to maintain their books and records to the requirements of the broker-dealer rules and regulations in the wake of the breach. What I find interesting about this one is it's the ripple effects of rulemakings. It's essentially what this case now stands for is that the level of books and records and reporting required of broker-dealers is so high that it cannot be satisfied manually. And therefore, ICBC was put in this fix of, once they had shut down their systems because of the intrusion into their systems, they couldn't keep up with their obligations, and they clearly realized this, went to the SEC, self-reported, and got a great deal of credit for having done so. But this is going to bring me to Nick's next question, which is what happens next what happens in the cyber world, given kind of these cases and where we think we're headed in the next administration. And I've been refreshing as we speak. It still looks like we are only rumored that the next chairman will be Paul Atkins, but let's assume for the moment that it is Paul Atkins. Paul Atkins, in addition to being an extraordinarily smart, talented professional, great presence for the SEC, I think is fair to describe as something of a textualist. So I think what happens to these cases is, assuming someone like Paul or Paul himself is sitting in the seat of chairman, is that some of the things that we see about kind of stretching the parameters of internal accounting controls and stretching what is material on is it material to a reasonable investor within the total mix of information, you're going to be seeing a return to core principles in that space, which will also mean that it will be more difficult to bring these types of cases. That said, there is rulemaking in this space as well. So assuming that the rules that were also came out in fiscal year 2024 are not wound back, you will see enforcement actions that stem from violations of the letter of the rules. But those are still going to be through the lens of long-established principles of materiality. And overall, I think that's going to be a good thing in this space. It will provide clear guidance, clear protocols for how companies actually can conduct themselves, and less of that Monday morning quarterbacking and less of the victim blaming that we saw in fiscal year 24.
Your point about Commissioner Atkins or potentially Chair Atkins being a textualist and not really taking full advantage of the benefit of hindsight. You may recall what he did when he was a commissioner with Reg FD. Really not a fan of doing what the SEC has been doing in these cyber breach cases, which is coming in after the fact and sort of parsing out, you could have disclosed this then. And so it will be interesting to see what they do, even with the litigated SolarWinds case. I guess you got to plow forward. But anyway, great report, Sarah. Thank you for doing that. And with that, since you ended with the broker-dealer case, maybe we can shift over to Art Zwickel. Not to talk about broker-dealers specifically, but Art, your practice at Paul Hastings, of course, covers a broad range of private fund advisors, hedge funds, broker-dealers, private equity funds, family offices. I could go on. And that's another space where the SEC has been quite active in 2024, and so have the courts. What did you see looking over the SEC Enforcement Division's efforts in the private fund advisor and adjacent spaces that you thought was noteworthy?
Sure. Well, starting with the report itself, I think there are probably three things that jumped out at me, at least one that's specifically talked about in the report, and then a couple others that were in some more significant enforcement type things that occurred over the course of the year that impact asset management firms. So I would start with the off-channel communications, which is one of the highlights in the report. As everyone knows, these are cases that have been brought by the Enforcement Division against a variety of market participants who are regulated entities that are subject to record-keeping rules, principally investment advisors, broker-dealers, and the like, where firms failed to capture certain electronic communications, and that was therefore deemed to be a violation of the record-keeping rules. And these cases have been ongoing since 2021, so they are not new as a general matter. The SEC has brought to date over 80 of these cases against over 100 entities, and they've imposed close to $3 billion in civil penalties against those firms. So it has obviously caught the attention of the industry and our clients. I think the two principal developments that the asset management industry worries about is one, the SEC started these cases against broker-dealers, and then they've been sort of expanding them first to sort of dual registrants, and now you have cases against standalone investment advisory firms. And every client worries that when the SEC comes in for an exam, are they going to be a target? Because even though most of our folks in the industry have put in place policies and procedures, they do training, they remind people what they should be not doing in terms of off-channel communications. Many have, firm-only business devices, but regardless, not everybody pays attention to what they're supposed to be doing, and applications like WhatsApp and text messaging, messages still don't get captured by the firm. there is some hope. There were 2 settled enforcement cases in September that for the first time did not involve any civil penalties against the registered entity. And also they did not require that an independent compliance consultant be retained to come in and, evaluate the policies and procedures that the firm had to make recommendations. These cases involved folks who self-reported, who cooperated, who had policies and procedures in place, and had seemingly done everything that you could do for quite a bit of time before the issue was reported to try to prohibit these off-channel communications, and yet they occurred, and the SEC allowed them to get away with the slap on the wrist, right? This was followed immediately by commentary by Commissioners Yates and Pierce saying that they, imploring the staff to sort of reevaluate its approach with respect to these cases. I think a lot of people in the industry feel like this is not a case where there's a lot of harm to anyone, other than it may inhibit the SEC's ability to sort of pursue cases against other folks and do their investigations, and that's why the record keeping rules are important. But maybe it's time for a change, right? And so anticipating your question at the end with this particular matter is with basically the commission being reconstituted, hopefully we'll see a slowdown in these cases, or at least more acknowledgement that the industry is doing what it can do to prevent this. I think people have gotten the message by this point, and hopefully we won't see these significant announcements of multiple settled cases involving hundreds of millions of dollars in penalties going forward. The other 2 items that I would want to talk about on the enforcement side, the first one is the marketing rule and some of the enforcement cases around that. The marketing rule was adopted or the compliance date was about 2 years ago. So it's been in effect for 2 years. We started seeing the examinations division honing in on marketing rule compliance probably toward the second half of 2023 and going into 2024 from an examinations perspective. And then earlier this year, you had the inevitable enforcement cases. So there was a handful so far, only a trio. Those cases, I'm sorry, the first ones were earlier this year. There's now been more than a dozen cases, and they generally involve things like advertisements with misleading performance information. The use of hypothetical performance has been a big one where it's not been tailored to the recipient who's getting that information. And then also the testimonial and endorsement area where firms have used compensated endorsers without really disclosing that. So you have seen some of these enforcement cases. The fines have not been significant. They kind of range from the $50,000, $60,000 range to the low, 6 figures to $300,000. So nothing that's where they're imposing millions of dollars in penalties, but it has, again, it's something that our clients are focused on in terms of regulatory compliance and not wanting to be one of the next round of cases. The other area in the enforcement area is AI washing. So this is the new greenwashing. So if you recall, there were a number of cases brought against firms and continue to be brought against firms for touting ESG related attributes of their firm or their investment process when they weren't really following what they were saying. They weren't really doing what they were saying. So AI washing is new. This is where you have seen the first enforcement cases in 2024. And in that case, you have advisory firms or asset managers who are touting the use of AI in their investment process as a material part of what they do. And again, they're not really, it's more like marketing shtick. They're not really doing what they say that they're doing. And it's something that the commission has taken issue with. So again, we're advising our clients just to be careful about that in terms of the way that they disclose the use of AI. And there's a balance, of course, because on the one hand, you're required to disclose in your Form ADV, how you evaluate securities and things like that. So you want to talk about AI, but you don't want to go over the top. So it's something to keep an eye on.
Yeah.
So shifting then away from what I'll call the enforcement part of it to more developments in the litigation area, which you alluded to. I think the big news of the year was the private fund advisor rules. And those rules had been adopted in 2023. It was a series of related rules that would have imposed significant burdens on private fund advisors. And they ranged from, what was called preferential treatment provided to investors and prohibitions on certain activities, increased financial reporting obligations, changes to audit requirements, and additional requirements that would have been imposed on advisor-led secondary transactions. And the industry as a whole really objected to those rules. And so you saw promptly after they were adopted, a group of industry trade associations brought a lawsuit in the Fifth Circuit trying to challenge the rules. And in June, the Fifth Circuit Court of Appeals actually vacated the rules in their entirety, finding that the SEC had exceeded its statutory authority in adopting those rules. And I know ICAN submitted an amicus brief in that particular case, and we worked on that together a bit. And the good news for the industry was that the SEC ultimately decided not to appeal that decision. And so it looks like those rules are dead and unlikely to be resurrected in the future, at least not in that form. The other, litigation area that's on people's radar has to do with the short selling rule and the securities lending rule. These were rules that were adopted together at the end of 2023. And again, promptly after they were adopted, some trade associations filed a lawsuit also in the Fifth Circuit challenging those rules. But the reasons were a little bit different. In the short selling rule, that rule basically imposes requirements on institutional investment managers to report information on their short sales. It's on a slightly delayed basis. It's 2 weeks, after the end of each month. And the delay was intended to sort of prevent harm to the asset managers and their clients, because you didn't want to sort of telegraph what these firms were doing in real time, because it could lead to things like a short squeeze, right? Which you saw in the GameStop case, and that got a lot of headlines. And so there were some concerns about that. But then in parallel, the SEC adopted a securities lending rule, which now requires that details of securities lending transactions have to be reported to a registered National Securities Association like FINRA on a daily basis. And even though some of those details, like on a firm basis, are not disclosed, you can, with the other reporting out there, you can kind of put 2 and 2 together, because there will be aggregated reporting. So the rules are kind of interconnected, and it didn't seem to make a lot of sense to have one rule that said you have to disclose daily, and then one, to protect everyone involved, you would disclose on a delayed basis. So it's really that interconnectedness that is an issue. And the plaintiffs have also challenged what they call a flawed cost benefit analysis and all the other usual things you see these days in lawsuits against the SEC. But the key is that the compliance date for the new short selling rule is January 2nd of this coming year. So from a litigation perspective, that is moved forward in October. There were oral arguments before a panel at the Fifth Circuit. And, the reporting out of the discussion among the lawyers and the judges was a bit mixed, but it does appear that there is some skepticism about whether these rules actually were thought through properly. Don't know whether there's going to be a decision that will be issued. As far as I know, one hasn't been issued yet. And I don't know that we'll have one before January 2nd. But I think people have their fingers crossed, although it's getting late in the year. But that was the other sort of significant thing. And then anticipating, again, your question about what would we see going forward, I would say that from a regulatory perspective, the industry has just been complaining very loudly for the last couple of years about the pace of SEC rulemaking impacting these firms, right? And the amount of resources and time that it's taking to comply and get ready to comply with these rules. And so I think that you will definitely see a slowdown in that pace of rulemaking. A lot of the rules that are in proposed form that were, on the agenda to get approved either this fall or in the spring, they may not ever get approved, right? And there's things like changes to the custody rule, there's the cybersecurity rules, there's a bunch of things that are still pending the use of third parties. So I think that you will see a slowdown for sure on that side. On the enforcement side, I don't know that you're going to see a huge change. Hopefully, as the others on this webcast have talked about, that we won't see like ticky-tack violations or minor violations being turned into something bigger, or the SEC stretching the interpretations of certain rules to kind of bring cases that don't make a lot of sense or couldn't have been anticipated. So I think that there's hope for that. But in terms of the letter of the rules, I think you'll continue to see enforcement actions in that area.
The ticky-tack, another phrase for that is the broken windows philosophy that, of course, was famously implemented in New York City on criminal matters, but also by a former chair, Mary Jo White. It sounds like what you're saying, Art, is the hopeful interpretation or prediction of what's going to come is that maybe we will not see a return of broken windows policing where every small violation is pursued as an enforcement matter.
Correct.
Yeah. Well, one area to shift over to Tom, one area that private fund advisors sometimes get criticized for is their handling of material non-public information, which of course the handling of that information can result in allegations of insider trading. Tom, I know this is a particular topic of interest for you. Developments and I wouldn't limit it to insider trading because frankly, some of the insider trading like cases are not actually insider trading cases, but what have you seen in 2024 in the enforcement division's report or elsewhere, developments in this area?
Well, that's a great segue, Nick. And let me just start with the numbers. The commission brought, according to its report, 35 insider trading cases in 2024. That's pretty consistent with the last couple of years. They brought 32 in 2023 and 43 in 2022. Insider trading is not a big part of the enforcement program. The 35 cases were about 8% of their total cases. And that's consistent with the numbers of the last few years. But I'm going to start with what you raised, and that are cases, enforcement cases that involve the mishandling of material non-public information, but no insider trading. And this would be particularly noteworthy to Art's clients because these are investment advisors who have access to material non-public information. In one case, the advisor frequently advised companies on potential mergers with procedures in place that they would not share that information unless necessary for their business. But despite those processes and procedures, they in fact did share potential mergers with their clients, their retail clients. The SEC said, charged that firm not with insider trading, but with failing to comply with their own internal procedures about the protection and handling of material non-public information. In a second case against an asset manager, very similar, the asset manager sat on creditors' committees, had access to material non-public information. There were procedures in place that prevented the sharing of that information with others in the investment advisor, but those procedures were not followed. Commission, again, brought a case against that advisor for failing to live up to and comply with its internal procedures. We saw this a few years ago in Los Angeles with a case against Ares. And I think the takeaway from these cases for investment advisors is you have to have procedures in place to prevent the misuse of MNPI, and then you have to actually follow those procedures. Even if there isn't any actual insider trading alleged, the mere failure to follow your procedures is enough. So that's one area. The second area, which I think also impacts investment advisors and others, is shadow insider trading. I don't think any discussion about insider trading would be complete without discussing shadow insider trading. The case, of course, is SEC versus Panawatt, which went to trial in 2024. Panawatt was found by a jury to have engaged in insider trading. Very briefly, the facts there are Panawatt was an employee of a pharmaceutical company that was in discussions of being acquired by a much larger company. Panawatt made the determination that if his company was in play, other similarly situated companies might be in play as well. And he bought options in a similar company after the announcement of the acquisition of his company. This other company's stock went up 8%. He exercised the options, sold his shares, made a nice little profit on it. The commission alleged that that was a misappropriation under the misappropriation theory of insider trading. I think when the case first came out, many of us were up in arms that that was a real stretch of misappropriation. Having learned the evidence and the facts, it doesn't seem less outrageous. It seems less outrageous. Mr. Panawatt was a former investment banker, so understood a little bit more about how the mergers would play out or the acquisition would play out, and actually attended meetings within his company that specifically identified the company he invested in as a potential benefit, potential company to be acquired by other companies. So he did have material information. I think what we all worry about is, now that the commission has this victory, how far are they going to take it? Are they going to extend it to client, like arch clients who all the employees make a living guessing at what's going to happen next based upon facts they're aware of? If you don't have the unique facts that existed in Panawatt, will the commission be responsible in deciding what shadow insider trading cases to bring? That remains to be seen, and hopefully with a new, perhaps more conservative commission, we'll see fewer types of those cases. And then the last case I want to talk about doesn't involve the SEC and doesn't involve insider trading, but it could have a enormous impact on insider trading cases, and that is the Loper case, in which the Supreme Court decided to end the Chevron deference theory, so that federal courts no longer have to give deference to federal agency interpretations of federal law. And you ask, why is this relevant to insider trading? Well, it requires us to turn back the clock 25 years before Rule 10b5-1 was adopted. And Nick, you and I both were at the commission, as was Lisa at that time in the LA office. And you remember that in insider trading cases, we struggled with what the commission had to show to prove that the person abused material non-public information. And there's no statute, there's no insider trading statute, so it's not defined. And there were some circuits that said that the commission could show scienter merely by showing that the actor possessed material non-public information and made a trade. Other circuits said, no, the SEC has to actually show that the actor used the information in making a trade, which is a much more difficult standard. The Ninth Circuit, where you and I and Lisa and Art are located, never addressed that issue in an SEC case, but in a criminal case said you have to show use. Anyway, the commission adopted Rule 10b5-1, I believe, in 2001. And what the rule said is it did away with the use versus possession debate and said, as long as the actor, the trader, was aware of material non-public information, that's all the SEC needs to show. But the defendant could show as an affirmative defense that he didn't actually use the information. There was something else he or she relied on to make the trade. So for the last 20 plus years, whenever cases have gone to trial, or whenever the standard of proof has been challenged, the commission has relied upon the Chevron deference theory and argued that the court should defer to the interpretation of Rule 10b5-1 and follow the awareness standard rather than adopting a more difficult use standard. I've tried insider trading cases. You have, Nick. I've sat in jury instruction conferences where that exact argument was made, and the court decided to go with the SEC's interpretation in Rule 10b5-1. My view is that that's dead. That the next insider trading case that goes to trial in the Ninth Circuit or anywhere, the defense should be arguing the use standard and arguing that Loper says the court doesn't need to follow Chevron deference and follow Rule 10b5-1. And, who knows how far this goes. I'm kind of excited to see what the Supreme Court may do next. Lisa, you've got SAB 99, which is the commission's interpretation of materiality, and that's followed by many courts routinely. And why doesn't someone argue that the court shouldn't give any deference to that rule and apply the Basic versus Levinson standard? In any event, still remains to be seen what's going to happen with Chevron and how it will play out in insider trading cases. And the last thing I'll mention is going to disgorgement in insider trading cases. And this was a case decided in the last few days and related to the Martoma long-running standard, long-running case in the Second Circuit on insider trading. There, the court ordered disgorgement, and under the Luke case, in order to get disgorgement, the commission has to show that there were actual victims. The commission actually traced, it was insider trading, the commission actually traced the victims of those trades, the people who were trading contemporaneously with the insider trades in order to get disgorgement, which is fascinating that the commission has that ability. And I was living a false dream that disgorgement would not be available in insider trading cases because you can never trace the victims, but the commission has now burst that bubble. So we'll see what happens this coming year in insider trading.
Yeah, it's interesting, Tom. You mentioned Panawat. Just for the record, I am still up in arms about the Panawat decision, and it's on appeal to the Ninth Circuit. So, maybe that'll be the case where the bounds of insider trading get tested in the Supreme Court if it goes.
Yeah, absolutely. And ICAN has been an amicus in those cases.
Yeah. Well, gosh, we've covered a lot of ground. Tom, just for completeness, do you expect any difference in the insider trading program in a new administration?
I don't. It's been a small part of the enforcement program, and I don't expect there to be many changes. It's been pretty constant over the last few decades. So,
right. Maybe they won't bring any expanded shadow insider trading cases, but I guess we'll have to wait and see. Well, that's a lot. We'll leave it there. And until next year's enforcement report, where we compare, administration to administration. In the meantime, thank you, Rodrigo, Lisa, Sarah, Art, and Tom, and everybody else. Please tune into the next SEC Roundup. Thank you.